Well, good morning, everybody. Oh, geez, we can do better than that. Nothing's more riveting than an early morning talking about intellectual property in my world. Woo! I don't know about yours. Yeah. Woo! Thank you. My people. Jeez. So some of you have heard this story. I recently was revisiting it. I traveled with Senator Lindsey Graham and a bipartisan group of senators to Europe and Africa 2 weeks ago. And I said, Lindsey, I've told this story before, and I just want to make sure it's correct. That as we were flying back now 5 years ago from a conference in Munich, I buttonholed you for an hour to just make sure I could get my views on intellectual property heard. Just a brief hour-long conversation about patents and about the PTAB and about fee diversion and some of the more pressing issues that really weigh on my heart. And as we landed in Charleston, he sort of staggered off and turned to the other senators and said, I have a new idea for how to torture people at Guantanamo. Make them listen to Chris Coons talk about IP for an hour. And I said, does that mean I've got your vote? He goes, God, shut up! So when my folks told me I had a chance to be in a room with a whole bunch of people who care about IP, nothing, Jessica, nothing excites me more than a chance to get together and visit about IP. Apparently, I was the keynote of your last in-person conference. So if you want to cure a pandemic, just invite me to Keynote. It's going to wipe away all the challenges or problems. And I know that's no laughing matter, but I just figured I'd say, great to see all of you in person. Although Zoom is a wonderful invention, and it's lovely to be able to give remarks and hear remarks while sitting in our pajamas in our bedrooms with our kids and dogs running around. It is so much easier to focus and to communicate and to engage in person. So thank you. Those of you who've had the ability and the time to invest in being here. There's a number of Delawareans who were going to be here today who I understand may not because of the vagaries of travel. I understood that Brian Dorini and Steve Ackerley from InterDigital and Jessica Sinat from DuPont were going to be joining today. Jessica, I hope, is she the one who is not going to be joining today? No, someone else, so my apologies. For those three folks who are going to succeed me or follow on the panel, they will have far more substantive things to say. I am, after all, just a senator, not a patent holder, not a practitioner. In my family, I have relatives who still wonder why they pay me, what they pay me for, and what it is that we do. So thank you for an opportunity to spend a few minutes sharing both about what I hope is our common commitment to the value of innovation and invention and what I hope we can accomplish in the Senate Judiciary Committee in this session of Congress. I am grateful to IPO. It is important to have a convening organization that has professionals who represent some of America's and our world's most innovative companies. To have in one place at one time folks who hopefully can come to some consensus and then offer input, advice, engagement, advocacy that's effective. Because at the end of the day, what most members of Congress want out of our IP system is a stronger, more innovative, more competitive America, and to have a better platform on the world stage for us to advance the concerns and interests of either American headquartered companies or companies that have a major impact on the United States or that have a major role in our world. Some of you may have noticed that Congress occasionally struggles to legislate in a timely, precise, and effective way on matters that relate to technology. Little head nod, yeah, a lot of head nod. A lot of knowing smiles. And I will tell you that one of the things that helps make us more effective when we legislate is when we've got a trade organization that is able to hear from and then coalesce a wide diversity of approaches and priorities. I'm genuinely concerned about where the United States stands in the world in terms of our IP system. And in the decades since I took the bar and joined the Delaware Bar, and the many years now since I was practicing for a privately held company in Newark, Delaware, that was a global manufacturing company, we've seen a significant shift, in my view, in terms of the competitive threat environment in the world, what the underlying rules and system looks like, and where we stand globally. So Robert from J&J and I were visiting about the time that I spent at W.L. Gordon Associates. Our companies litigated against each other with some regularity, and he was delightfully complimentary. And I said, that's really because J&J won most of the cases that I was involved in. It makes it easy to be complimentary. But he shared a simple truth that I couldn't agree with more, which is that what we really looked for was a fair system with clear and predictable rules, where we knew as in-house counsel we were able to give advice to our C-suite about pricing risk, about where to license, where not, where to litigate, where not, where it was worth it, where it was not, and across a wide range of issues, from trademarks to copyrights to patents to trade secrets. What was the environment? Some of you know that Delaware is a special place. I grew up in a neighborhood where 10 out of 14 of the heads of household in the little neighborhood where we moved in 1970 were DuPont chemical engineers. My Boy Scout troop master would lecture me about how he had the patent for the lining on soda bottles. Our pastor was someone who had had a mid-career shift from being an inventor and entrepreneur to someone who had a more spiritual side, although I think invention is a pretty spiritual act. And, you know, frankly, my high school chemistry teacher had a PhD in 9 patents. So I grew up in a world where I thought patents were the most important thing in the world. And frankly, I still think they are. It just makes me a small subset of the 100 members of Congress with whom I serve. I hope that you have a sense of optimism about our place in the world, but I hope that you also see the challenges, both no longer on the horizon, but right up close. ITIF, Rob Atkinson's been running ITF for quite some time, and he recently released a report that I found engaging and concerning about China is no longer approaching us in their innovative capacity. They're outpacing us in some of the most critical areas: artificial intelligence, quantum computing. There's others in biopharma and other areas of innovation where we maintain our competitive advantage, but frankly, we're moving from a place where China is mostly a challenge to us in terms of theft of IP, of trade secrets, and infringement of patents, and now they have, I think, a credible goal to be a global leader in IP protection by 2025. The fight over the leadership of WIPO is a reminder that the UN system, something widely ignored by senators or at best dismissed, actually really matters. Standard setting bodies, the global rules for trade, for innovation, for the protection of IP genuinely matter. And in my view, we've weakened our own IP system domestically in ways that I worry about. I think serial PTAB review of patents wear down patent owners and make it harder for a genuinely disruptive, creative innovator to rely on a patent as the true right to exclude others into practice. And I think there's some serious questions which Senator Tillis and I delved into at great length in a previous Congress that muddy questions about 101, about patent eligibility, that I think are hindering our ability to bring to market genuinely next generation technologies and medical diagnostics which no longer qualify for patent protection. The Supreme Court is taking up, I think, 3 different IP-related cases soon. We'll see how their jurisprudence continues to be polite, evolve. So I do look forward to their direction in some cases, and in other cases, it's up to us to legislate. I think some of you are clear that I'm now the chairman of the IP subcommittee. I don't remember if that was part of the introduction, but Senator Tillis is the ranking member and I'm the chairman. And if you don't know Senator Tom Tillis, Republican of North Carolina, I feel very fortunate to have him as a partner. He's from Research Triangle. He's from a community and a personal background and a career experience that makes him care deeply about innovation and has given him some insight into the role of IP. We don't completely align on everything, but I was really encouraged that at the end of last Congress, before we knew the outcome of the elections, he and I spoke to a group together. He stood up first and said, it doesn't matter who's going to win the election. It doesn't matter whether I'm the chairman and Chris is ranking, or he's the chairman and I'm the ranking. We're going to pull together in the same direction. We're going to come up with a common agenda for hearings. We're going to welcome input and advice from a broadly representative group of folks from the IP community. And I just wanted to give you that as what I think is one small encouraging note in a Congress where bluntly the disagreements over things as simple as the debt ceiling or as foundational about whether we'll continue to honor America's sovereign debt. Some of the disagreements we're having over what happened on January 6th, does it matter, and what should we do about it? These are disturbingly foundational. For me to have found a legislative partner in Tom Tillis, where we have mutual respect, where staff work well together, I think is a very positive thing. And an important part of that is Michelle Ankenbrand, who's my IP attorney, who is rolling her eyes at my calling her out in front of the crowd. You can just give her a nice polite round of applause and not interrupt her life. But in case you didn't already know this, you figured it out by now. I am only a minimally competent IP legislator because of the talented patent attorneys who I'm blessed to have served with me over several years. Michelle's here as a DTLE from the PTO, also a PTAB judge, also a Delaware resident. So she's got a lot of great things going for her. We've worked out an agenda for this Congress. Our first hearing will be on April 18th. I expect everyone to come. There will be snacks and commemorative medallions, and I'm kidding. But I'm hoping that it will be worth your time, and we look for your input. The first one is really about the global threats to U.S. leadership and IP. We're going to look at how competition, yes, with China, but with many countries, changes in our own laws and in laws and regulations around the world is creating a different environment that we're going to highlight. The amount of trade secret theft, for example, something I legislated on when I first got to Congress. It's been estimated at $600 billion a year. Senator Hatch, Senator Orrin Hatch of Utah, and I wrote the Defend Trade Secrets Act of 2016 was when it finally was signed into law, and it provided for a civil cause of action for trade secret misappropriation and allowed companies to move a little bit more swiftly than simply waiting for a U.S. attorney to agree to combat theft. I've got a whole bunch of different pieces of legislation I'm going to briefly mention and hearings that we hope to have in this Congress. I'm going to introduce the Secrets Act again. Senator Cornyn of Texas and I worked through this. It would provide streamlined procedures to block the importation of goods made using stolen trade secrets. So building on the legislation with Orrin Hatch, Senator Cornyn, who is a very serious legislator, someone I'm grateful for his partnership in this as a way of defending trade secrets that have been stolen or infringed. I'm also concerned about trademark threats. Senator Grassley and I are the co-chairs of the Trademark Caucus, and although we disagree on a lot of other things, we've found common ground in trying to elevate and protect trademarks. We have found that online marketplaces, as I suspect you know better than any group I could talk to, are flooded with counterfeit goods. Counterfeit goods which are not just harmful because they impact your bottom line, but are harmful to consumers. On a previous Congress, we had a hearing where Senator Tillis was very excited about this. As a mountain biker, we put out a genuine article mountain bike helmet and a counterfeit mountain bike helmet and showed that this one resisted impact, this one shattered almost immediately. In Africa, where I've traveled and worked a fair amount, the cost, the human cost as well as the financial cost of counterfeit pharmaceuticals is a very real challenge. Counterfeit aircraft parts, counterfeit N95 masks during the height of the pandemic are all real threats to human safety and health. And the United States seizes something like $1 billion a year of counterfeit goods, but by some estimates, we miss over 80%. So I do want to do more to make sure that we are protecting trademarks and protecting American consumers from counterfeits. Something Senator Tillis and I introduced in the last Congress called the Shop Safe Act would incentivize online platforms to adopt identified best practices to limit third-party sales of harmful counterfeits. I'm hopeful that we can get some movement on that. I'm sure it will not surprise you, one of our early hearings will also be to have PTO Director Kathy Vidal up to talk with us about the health and the trajectory of the Patent and Trademark Office. She's made a number of decisions around PTAB and discretionary review that I'm going to want to go over. She's had some strong initiatives around diversity and inclusion, around engagement, education, and outreach. She really has a passion for motivating and engaging younger Americans to understand the IP system. She may be more effective at that than I was with Lindsey Graham. I hope for that. And we'll also just look at the central role that patents and trademarks and other IP play in our economic vitality. Hopefully we'll be able to attract some other senators to participate in that. I have a piece of legislation I have championed across several Congresses, the Strong Patents Act and the Stronger Patents Act, which we're going to split into two. I will likely introduce the Prevail Act, which would harmonize PTAB and district court standards and eliminate what I view as abusive serial attacks through the PTAB, and another which we'll call the Restore Act to restore the rebuttable presumption, which would make it easier for inventors to seek injunctive relief. My own experience having suggested that that might be an important feature. There's also agreement with Senator Tillis that artificial intelligence is posing a genuine challenge that we don't fully grasp yet, both in terms of what it makes possible, for searching and for patent, for research and for invention. But the relationship between IP rights and AI, that's a contour that we haven't fully or clearly defined yet. And so with the explosion of artificial intelligence and emerging technologies, I think we should be delving into that. That is in particular an area where we'd welcome across all of the, why am I here? I'm here because I'm inviting your input and participation. But we're just senators. We don't really know what's going on in the world or what's going on in the world of invention and innovation. With your advice and input, we are more likely to do a more competent job of engagement and advocacy. Let me briefly mention copyright because copyright would be wounded as a member of the IP family if I left the stage without some reference. I'm currently collecting bipartisan co-sponsors of something called the Pro Codes Act, which Cornyn and Tillis and several others will introduce. This really came out of, believe it or not, the NFPA and the Fire Service, something I've long been connected to. It would balance public access to codes and standards that have been incorporated by reference into law with copyright protection. Right now, one last issue, digital piracy is something that I think Tillis and I are interested in looking at further. Some estimates it costs us $30 billion a year and 250,000 jobs. So it is very difficult to police. We have some outdated and difficult to enforce statutes on the books, and a number of different rights holders and elements of the creative community are looking to us to figure out a better way to enforce rights that is more amenable to striking the right balance. So, look, I recognize part of the challenge of a trade association is you are a big tent with folks with a very wide range of views. Some of you are cheering me on and hoping that every piece of legislation I mention, every hearing will go well and will advance, and some of you are thinking, oh, what a dangerous jerk, oh my God, I wish you'd shut up. And the reality is, my goal really is to make sure that we achieve that vision of fair rules, reasonable procedures, so that you, as in-house counsel and as folks who are advocates for a strong IP system, can know where we're headed. I am hoping to work together with Senator Tillis and with partners in the House to strengthen our IP system overall so that we as a nation are on a better and stronger footing across the globe, because I think IP matters. Is there anybody in this room that thinks IP matters? Am I in the right room? And there we go, ladies and gentlemen, I got them to raise their hands. Last thing I'll mention briefly, the District Court of Delaware, my pride and joy, is the busiest patent litigation court in America. And one of the things that senators get to do is to weigh in on who ought to be nominated to that very busy court. One of the things I have prioritized is making sure that we have judicial nominees with experience in IP. And we are right now in a selection process where you can just rest assured that that is one of the factors I weigh and weigh heavily, is making sure that we have a bench, a bar, a community in Delaware that is respectful, welcoming, supportive, but where the folks who have the remarkable power of a district court judge, folks we are asking to take on an enormous weighted caseload average, that they have relevant experience and that they're able to render important decisions in the cases you bring in Delaware. So if anyone comes to Delaware to litigate, please drop by. My office is just a block away from the courthouse. We'd welcome a visitor anytime. I'm partly kidding, but really not really, actually. And I will close by saying this. The bills are important, the hearings are important, but more than anything, I think it's important that we as a nation achieve consensus. I was speaking to a group of college kids last night who came to visit from the small college I'd gone to, and one of them said, what's your closing message? And I said, more than anything else, our Congress, our country only works if there's compromise. Without compromise, we might as well just move to full-on armed conflict, because Congress is pointless if you elect people and send them here who have no intention of compromise. So this organization can help model the value of compromise, of listening to each other, of putting important and tough issues, complex issues on the table, and then helping bring to those of us who serve you in the Senate with resolution. When I was first elected, a talented man named Lamar Alexander, former senator from Tennessee, I suspect known to many of you, sat me down and described the really complicated mess around songwriters and performance and music, and the real disconnect because of disruptive technology in a decades-old consent decree. And he described what he imagined might somehow be a resolution of an incredibly impacted, complicated series of issues that really had been litigated over and litigated over. We met over this several times. Several years later, I was in the White House as a previous president, signed into law a resolution of that. That was really resolved because of negotiations between the rights holders, the litigants, the creators, the community. It's not that brilliant, I mean, Senator Alexander, of course, was the person who really made all of this happen. But at the end of the day, as one of the folks whose name is on one of those bills, we were able to get that bill to the president's desk because the community of interest compromised, came together, handed us a reasonable path forward. You can play an incredibly important role in the future of IP, not just in the United States, but in the world. So thank you. Thank you for who you are and what you do, and I look forward to working together in this Congress. Thank you very much.